Start your journey today by liking, subscribing, and sharing our YouTube channel, Knowledge Well Media, or by going to our Square site at knowledgewell-media.square.site and perusing over the available content and information. Also by submitting your email at the bottom of the Square site page in the Stay in the Loop section to receive priority information, specials, and other insider details. Or by signing up for a 1-hour consultation to tailor your specific educational needs in beginning your journey. You may do so at the aforementioned Square site, once again at knowledgewell-media.square.site. Here are a few other items in demand on our Square site. The Person Defined series, a 9-part video lecture series, comprehensively outlining the scheme to artfully deceive mankind into trading away his birthright, his natural liberties, and inherent rights. Pre-orders for The Yellow Bricks of Emerald, the first edition, offered presently as an ebook only. This book comprehensively uncovers the legal schemes, past, present, and future, of the elite powers and the U.S., subjecting American citizens to servitude and allegiance due to their own ignorance. The Knowledge Well Video Lecture Series Trust Course, a comprehensive lecture series educating on the history, effects, and administration of the wealth-preserving, asset-protecting, private commercial entity known as a trust. Plus, we have our very own template and instructions to help you set up yours. And, coming soon, our apparel and product store for all things Knowledge Well, including shirts, hats, jackets, cups, bumper stickers, and more. For all this and much, much more, as well as for any questions or comments, email to knowledgewell4u@gmail.com or go to our Square site at knowledgewell-media.square.site. And now, you've been made free. What are you going to do with it? All right, testing. Can you all hear me? Please let me know how the sound is. Welcome to this day of inspiration, this day of the sun. Let me know how the audio is. We'll see what kind of participation we get today, who takes their education serious or otherwise. I realize, I understand that it is a major sports day. I do partake, to get some levity, to do something different every once in a while. I get it. Definitely don't want to step on anyone's or make anybody feel guilty about, participating in sports and all that kind of thing. I'm very athletic. I like to stay engaged in what have you. So, not trying to guilt trip anybody. But we will stay. We won't stay on too long. So you can get back to your football. I'll probably watch. I usually like to watch like the second half of the game. The first half is, in my opinion, not really indicative of what's going to happen. Things change, situations change instantaneously. Someone gets injured, your star player, and then next thing you know, it's a whole different type of game anyways. Same thing with the season as a whole. I like to come in. I prefer to come in at the second half of the season as opposed to jumping on in the very beginning. I got so much mess here. Cost of doing business. But anyways, welcome. Make sure that you hit that thumbs up button as you come on in. And hey, if you're watching this on replay, the thumbs up button still works. Do your boy a favor and help us out with that, okay? Other than that, we had a very interesting conversation yesterday. I did a live, very passionate, very controversial, very abrasive, but I believe it is just that time. It's time to separate the wheat from the chaff. Wheat is the real McCoy, and then the chaff is a hollow piece of unnecessary, as it were, weed. There's a difference between the wheat and the chaff. And I just believe that that's what time it is. Too many people are complaining about being taken advantage of and have spending lots of time exhausting different remedies, going through different gurus and what have you without remedy. So if you're like me, then you're pretty much tired of it and ready to come to a conclusion on who and what the real McCoy is. So Knowledge Well will be leading the fight, the battle, as it were, as pertains to that situation and matter. So if you didn't watch yesterday's live, make sure that you go and check it out for information, for action steps you can take to address that very issue. It's time to move on. It's time to move forward. All right. Enough of the games, the disinformation, misinformation, whatever. And I did issue a warning that Knowledge Well Media will be using this platform to disprove all of those teachings that are leading people away from the actual truth. So we put them on notice. We put all those gurus on notice that a challenge will be issued if you are found to be unjustly enriching yourself at the peril of people who are hungry for actual truth and knowledge. True worshipers, as the scripture says, will worship in spirit and in truth. Okay? Spirit comes from the Latin spirare, meaning to breathe. So the true worshipers will worship in breath and in truth. Later for that. Happy Sunday. Today is what? What is today? It's October the 8th, 2023. Let's get this thing going. I thought it would be fitting to read over a case. My moniker, my sub slogan will be, if it is not found in law, or if it is not backed by law or by case law or by statute, regardless of how you feel about the situation, then there is no legally protectable interest. Okay? If you can't find it in law, now you might want to be disenfranchised, separate yourself. You can exercise your natural and inherent right to expatriate from the United States. That is up to you. That is every individual's choice. But as long as you are here, your family is here, your legacy is here, your inheritance and inheritors are here, the only way to play this game and to become successful at it is to play in accordance with the procedures that have been established. That's the only way. Okay? And so myself and other gurus and platforms do you a disservice if we try to guide you or lead you down any other pathway that is, as long as you're underneath or within the legal order of the United States, the American jurisprudence. If we lead you down any other pathway, we are doing you a disservice. And there is no remedy then. All right? That's just the nuts and bolts of it. Okay? So here, if we can't find it in law, here, if there is no case law, common law, to back up our assertion, then we're simply not going to make the statement. Okay? Again, so I thought it would be fitting for us to go over a case law. And all gurus, again, be on notice and recognize that this is how you teach. This is how you instruct. Okay? This is how you admonish the people. Okay? So that you can keep them from going down erroneous pathways. Base your lectures, your studies, your teachings on the law. And then your remedy will have recognition in the law. If it makes sense, it makes dollars. Picking up what I'm putting down. Let's get started. Again, let me just make sure I put up my disclaimers here before we get going. None of what you are hearing or seeing should be construed to be legal advice. Okay, if you need legal advice, please seek yourself your own personal and individual attorney, and please be advised. All right, this is for educational purposes only. Testing 1 2. Please let me know how the sound is. Everybody's sleeping in today, but that's all right. I know they'll be trickling in here. All right. Let's see what else we got here. Any donations, if you appreciate the type of teaching you get here, you appreciate what we do here, and you want it to continue, the best way to do that is to donate at $ American Consulate. All right, it should be scrolling across the bottom of your screen. That's our Cash App. All right, and of course, KnowledgeWell Media, KnowledgeWell, the number 4, the letter U, at gmail.com is how you can contact us. All right. If you have questions or need a consultation, want to talk about a particular subject or topic, have a question, whether adverse or if you have an adverse position, you want to debate a topic so that we can hash out those things that may confuse you a bit. That's how you do it. Reach out to us at KnowledgeWell, the number 4, the letter U, at gmail.com. We also have our Square site where you can pick up, among other things, books, videos, lecture series, cups, mugs. We got water containers, thermoses, and whatever with the logo so that you can show brand loyalty and help support what we do here. Also, over at our Patreon, that's where we have our exclusive Insiders Club members. This is where we drop things that are meant to be kind of in the private as opposed to in the public for obvious reasons. Okay. All right, let's get it in. Let's get it on. Let's go. Let's talk. I'm going to be talking with you over a case. Let me see if I can put it up here. All right, I'm going to have to turn my phone down. I see what time it is. All right. And let me do my due diligence to make sure that you can see this. Let's see, where can I go? Let's do this one. There, you should be able to see that. Hopefully I'm not in the way. All right, as you can see, this is I usually try to stick with my own courts here in my state. You can look up similar actions in your own state, okay? Um, but for these intents and purposes, we're going to use Gerger v. Campbell, okay? And as you come in, please let me know what state you are listening from. Welcome. Happy Day of the Sun. Let me blow this up here and we'll get going here. All right. So Gerger versus Campbell. Okay. Supreme Court of Wisconsin. This is a 1980 case. And let's read. I usually start here, where it's kind of giving you an overview of what the case is pertaining to. It says the question on this review is whether the Court of Appeals correctly concluded that Arthur A. Campbell, the president of Northern Dye and Stamping Corporation, was acting in his, pay attention, supervisory capacity or official capacity, okay, or representative capacity as president of the corporation and not as a, co-employee. Okay. So the discussion and consideration is as to what type of capacity was Campbell operating in. Okay. So there's multiple capacities is the consideration. When he negligently designed, okay, and installed a modification to a hydraulic press, the subsequent operation of which resulted in an injury to the plaintiff, Larry A. Gerger, okay? We conclude that Campbell, right, in executing a corporate decision to modify the press and as part of the supervisory responsibility of his employer to furnish tools for an employee, was immunized from personal suit, and that the plaintiff was left to the exclusive remedy of workers' compensation. So if Campbell, who now we find was acting in a supervisory position under the corporate charter, okay, since he was working under the corporate title, the corporate capacity as president, and he was not merely acting as a co-employee, meaning working right next to Gerger, wearing a different hat as an employee as opposed to acting in his supervisory role, okay, then he could not be held personally liable. In other words, he would enjoy a type of immunity because I'm merely just working as a supervisor, not as an employee equal to Gerger. Because if he had been deemed to be a mere employee, acting in a capacity as an employee, then he could have been held personally liable. Okay, hope you're picking up what I'm putting down, but we'll go a little bit. I'll make sure that it's clear for you. Okay, so since he was found to be working, once again, Campbell was found to be working as the president or in a supervisory role under the corporate charter, then workers' compensation would cover him, insulate him personally from any liability. Because remember, the corporation provides you, any officer of the company or any shareholder, owner in the company, it provides a protective layer so that you are not personally liable. That is what corporations were created for, as intended by those who have plenary power over commerce and trade, the Congress, the third branch of the federal government. They have plenary powers. They created this scheme, this corporate scheme, because again, the founding fathers and their ilk and the colonizers, I'll just say the leaders of the colonies, they knew what this was all about when they came over here and set up camp and instituted and established plantations. They came over here for the idea of capitalism, industry, to produce, to engage in commerce and trade. That's why they came here and established this thing. And so, since that is true, remember, whenever you are participating in the sea of commerce, there are whales and sharks, pirates, sea urchins, stingrays. Your body is not meant to be there, not naturally. That is a place, a different realm, a different sphere, as it were. Humans are not supposed to be there. So since we're not supposed to be there, it becomes necessary for us to have a protective layer to keep us from becoming lunch for the shark. Okay? To insulate your human flesh and body from the frigid temperatures of the ocean or of the sea of commerce. That is why you enjoy or have been granted the ability through taking citizenship, through becoming a member of the United States. That is why you enjoy privileges and immunities as established under the 14th Amendment. And that's what this president is realizing now under the scrutiny of the law, that he will not be held personally liable for his activities because he is shielded by the corporate charter. In this case, being the president acting in a supervisory role when he made a what is it called? A modification to this press that subsequently resulted in the injury to Larry Gerger. Are you picking up what I'm putting down? I am giving you the nuts and bolts to help you understand the importance of the distinctive nature between your human body, which is insulated by your commercial or legal entity. Are you picking up what I'm putting down? There is nobody teaching like that. There is nobody teaching like this. I'm going to help you to understand it so that you can walk in light and no longer in darkness. Are you with me? Can I get an amen? Can I get a hallelujah? And true to form, true to my assertions and claims, I am bringing it through the law. I am not making up my own conjectural statements. No, I'm bringing it from the law as established. This is a Supreme Court ruling of the state of Wisconsin. Let's go forward. We conclude that Campbell, in executing a corporate decision, therefore he is invoking or has invoked the corporate protection that insulates him from personal liability. And therefore, in executing a corporate decision to modify the press, and as part of the supervisory responsibility of his employer, the employer is the company, the corporate company. Remember, it has its own separate identity. In law, it stands as a separate entity in the eyes or in contemplation of the law. That is why the corporate form is his employer, but he is acting as what? The president in a supervisory role. Are you picking up what I'm putting down? Okay. Of his employer to furnish tools for an employee. See, That was part of his supervisory duty to make sure that all of the employees have the tools and mechanisms that they need to perform their duty. You see, Campbell is again operating under the corporate form, which provides him legal protection from liability. He has limited liability protection. Let this be a lesson to you in the functionality of the United States and its instrumentalities. When you are acting under the corporate form, you are insulated. You have limited liability from whatever may ail you in your humanity. So use it in the proper capacity, lest ye lose or waive the corporate protection that you are afforded. Can I get an amen and holler? Y'all ain't talking to me. My comment section, I don't see anybody talking to me. Hit that thumbs up button. Anybody here? Let me know in the comment section. Shout out to state that you're listening from. Listen, he was acting in a supervisory role for the employee to furnish tools. Okay, so therefore was immunized. You want to talk about immunity? You want to know the true application of immunity? It's not the right to travel. No, that's not the type of immunities you may enjoy. For you are under the corporate charter. You have become a member. You have incorporated into the United States. Yes, you are separate and distinct from the entity, the corporate form. Yes. So you act in your proper and subsequent capacity to enjoy limited liability. And if you do it the correct way, then you may become immunized from personal suits or liability. Anybody talking to me today? Comment section. And that plaintiff was left to the exclusive remedy of workers' compensation. See, the injured worker, Gerger, could not sue the president personally, individually, affecting his personal assets, taking from his bottom line. They had to use, Gerger could only pursue after the exclusive remedy that is recognized by law when a worker is injured as an employee. Okay? And that is workers' compensation. That's why the law requires that a corporation that has employees must have or pay into the workers' compensation insurance. That's why. Moving forward, we affirm the decision of the Court of Appeals, which upheld the judgment of the trial court dismissing Gerger's complaint. Gerger lost that case because he tried to sue Campbell individually and personally. Let that be a lesson to you. You try to sue a police officer. You try to sue the president, an officer of a corporation. As long as they are acting in the proper capacity and have performed under their supervisory role, they cannot be held individually liable. Now, that does not say that you can't sue the company. That's the employer. The company is the employer, not necessarily the president. Not when it comes to a corporation. A corporation provides a separate entity. It stands by itself in the law. Moving forward. Is this good? Give me a 777. I got 5 people watching and I have no comments in my comment section. We're not doing that. We're not doing that. Because that suggests that people are here, someone's here to steal. We're not doing that. Listen, moving forward, the record shows that Gerger had been employed by Northern Dye, okay, and Stamping Corporation for a period of 2 weeks, when on September 20th, 1972, he sustained an injury to his left hand when parts of 3 fingers were pinched off by a hydraulic press. Gerger, you see how the numbers dropped, the viewership dropped when I said that? Because that's what people do. They're here to steal. It's going to be a new day. New day. Were pinched off by a hydraulic press. Gerger received workers' compensation payments. Subsequently, he commenced an action against Arthur A. Campbell, the president. Okay? The Wisconsin statute provides that the recovery of compensation is to be the exclusive remedy against the employer. Now, again, class, lost another viewer. Good riddance. I know what's going on. Called you. Listen, against the employer. Look, who is the employer in this situation? The employer in this situation is not the president. It's the corporation, as I stated before. So the exclusive remedy for an employee that gets injured is workers' compensation, not suing the officers of the company individually. Look, at the time of the injury, as consistently interpreted by this court, Section 102.29 permitted a third-party action against a co-employee. So at this point in time, at a particular time in the past, they did permit a third-party action against a co-employee, not against the officer or someone acting in their supervisory role on behalf of the employer, which is the state. Okay, which is the company. Section 102.032 has since been amended by Chapters 195, Section 2, Laws of 1977. This amendment eliminates the right to bring a common law action against another employee of the same employer. There you go. The law changes. That's the difference between positive law and natural law. Okay? Natural law is consistent. It doesn't change. And positive law changes continually. That's the way it rocks. Okay? This amendment eliminates the right to, okay, I already read that. However, at the same time this action was brought, the statutes allowed the assertion of a common law action against the co-employee, Arthur A. Campbell, okay? The record reveals that the defendant in this action, Arthur A. Campbell, which is the president, was the founder of Northern Dye and Stamping Corporation, and he ran the business as a sole proprietorship. Okay, until 1969. Now, remember, a sole proprietorship is in contrast or opposite to running a corporation. Okay, sole proprietor, the law sees as you or as the social security number, the legal name. That's how the law sees it. Okay, you are not separate from the sole proprietorship, hence the term sole. Okay. When the business was incorporated and he went into semi-retirement, okay, Campbell was president of the corporation and he retained 85% of the stock of the corporation, okay? Oh, important point I need to make here. Okay, it was a sole proprietorship until 1969. In 1969, the business was incorporated, meaning it took on the corporate form, meaning it went from the liability being absorbed individually as a sole proprietorship attached to the to the social security number and the legal name. It went from that form, a sole form, to in 1969, separate corporate form was established. That's called incorporation. What's the legal definition of a corporation? The legal process to create a separate entity. Okay, let me ask you a question. Did you incorporate into the United States? Let me ask it a different way. Did you become a citizen at birth of the United States?
If so, then you performed an act, a legal process to create a separate legal entity. All right, let's move forward. So the business incorporated, therefore a separate entity was born, and he went into semi-retirement. Campbell, being the defendant, who is also the founder and the president, et cetera, of Northern Dye or whatever. Campbell was president of the corporation, a corporate officer, and he retained 85% of the stock of the corporation. The balance of the stock was owned by his wife and 2 sons, meaning the remaining 15% of the stock was owned by his wife and 2 sons. The officers of the corporation were Campbell, his wife, daughter, and 2 sons. So they are acting in a supervisory role, not as employees per se. Okay. After the organization of the company into its corporate form, Campbell retired to live at Conover, Wisconsin, and left the day-to-day operations of the company to his 2 sons. Campbell received no pay as president of the corporation. Look, for tax avoidance purposes, at the time of the reorganization, he retained ownership of at least some of the machinery. Duly noted, right? Duly noted. This is what I'm talking about. We can make claims based on the holdings of the court within the law. So let me ask you something, class. What's one bona fide way that even the law will recognize that you can avoid taxes? You see how we just learned that? This is not my words. This is not conjecture. You can take this to the bank, because guess what? At the very least, if you formed a corporation and say, I need a way to avoid taxes, at the very least, you can cite to this case or one like it in your particular state, and the law will recognize your claim. Why? Because you have a legally protectable interest. How do we know that? Because we see it right here by the Supreme Court that says, what does it say? Campbell received no pay as president of the corporation. Look, for tax avoidance purposes, at the time of reorganization, he retained ownership of at least some of the machinery. In exchange for the, watch this, lease of the machinery to the corporation, he received monthly rental payments of $450 a month. Can you say hello, Donald Trump? Donald Trump, how do you avoid paying taxes? There's a loophole in the law, is what Mr. Trump said. And now you know what the loophole, or one of them, are. He is, look what he did. Look what he did. He retained ownership, he did, of at least some of the machinery. So he went out and bought machinery and rented it to the corporation, that separate legal entity, for $450 a month for tax avoidance strategies. You're welcome. Now go and make it happen. If they can do it, you can do it. Equal protection of the law, baby. You're welcome. And it's okay. So he received $450 a month, okay, because he was leasing or renting items, machinery, to the company. Tax avoidance strategy. Although the daily operation was left to his sons, he visited the plant approximately every 2 months. Sometime late in 1971, a decision was made to change the mechanical energizing system of the hydraulic press. The trial transcript satisfies us, as it did the Court of Appeals, that the undisputed evidence shows that this decision, listen, was a corporate one and not the individual decision of Arthur A. Campbell. Listen, this is how you play the game. You want to know how Donald Trump and the like and everybody else are playing this game? This is what I'm saying. You don't have to be foreign to the United States. You don't have to be a sovereign. You don't have to do none of that. You merely have to understand the corporate form and the protections that you enjoy having limited liability under the corporate form. That's all you have to do. And you're getting a lawful demonstration of that here. Just by reading, we read what, 2 paragraphs? And I've already given you a legally protectable interest. If you go start a corporation tomorrow, you can do this exact same thing. You can buy machinery and rent it to your own company, and it pays you a monthly bill for leasing the product. Because see, the people that know understand that the corporate existence is separate from myself. Even if I go and sign up or register and create a corporation, the law does not see the corporation as me. And therefore, I can act in a particular capacity where it's almost like I am leasing to a whole nother person that pays me for my stuff. So we see here that a corporate decision, not the law didn't see the decision to update, or change the mechanical energizing system of the hydraulic press. The law doesn't see that as an individual decision by Campbell. Why? Look what they said. It says the trial transcript satisfies us, as it did the Court of Appeals. So they look to the trial transcript to make a determination as to whether this is an individual decision by Arthur Campbell or a corporate decision by the officers of the company. There has to be a distinction. There are at least 2 separate capacities at work here: the individual capacity and the official capacity. This, my dear sir and ma'am, is the corporate form. This is what the United States was founded upon, as intended by the founding fathers. This is how it works. There is no other way. You must know and learn this system to be effective, efficient, proficient, and successful. Did I say that already? You have to learn this. All other ways will lead you down rabbit holes that you may never recover from. Isn't this simple? Isn't this simple? Listen, they use the trial transcript, the history of the case, to discover as to whether the decision was a corporate one or an individual decision. In making the changes, Campbell removed a gate guard from the press. The gate guard you're going to see is to protect fingers and things like that from going under the press. Okay? If that gate's not down, the press will not be energized. Okay? That's a protective mechanism. This guard was okay, here we go. This guard was designed to prevent an operator's hand from entering the danger zone when the press closed. As a substitute for the gate guard, the defendant, being Campbell, right, the president, founder, designed and assembled a 2-hand push button control which it was thought would keep the operator's hands out of the danger area because both hands were needed to push the button simultaneously in order to close the press. In other words, you know, you got to use both hands. So the idea was that, well, if they're using both hands, then they don't have one inside of the press. Logical, right? Reasonable. So he just changed the energizing mechanism of the machine. Remember, at first it was the gate close. Then your hands ain't in there, and the machine subsequently is energized. But he changed it for whatever reason. This new control was designed and installed by Arthur personally, by Campbell personally. The amended complaint alleged that Campbell was negligent. So this is what Gerber, that's what their claim is, that Campbell was negligent. Why? In manufacturing and installing the new press control. Why? Because the press control system allowed the press to close when only one of the buttons was depressed. Oh. So in Campbell's mind, it was a two-hand operation, therefore saving an individual from putting their hands accidentally in the machine. But Gerger is saying, I can press one button and it still will energize. Look, there was also evidence to show that the new safety control could be circumvented by pressing one of the buttons with a knee. You know how we do at work. We always trying to cut corners. We get good at it after a while, right? So, you know. And there was testimony at trial which showed that prior to the accident, Gerger was using a knee to actuate the machine and was able, therefore, to have one hand under the press. There was even testimony to it. Look, at the time of the accident, at the time the accident occurred, Campbell was not on the premises, okay? The case went to trial. And at the close of evidence, the defendant renewed his motion for a directed verdict. Okay, so you're going to learn another instrumentality of the legal system as well here today. Okay, asserting as a matter of law, okay, Campbell was not a co-employee. You're going to learn what the directed verdict is, okay? Just hold on. This is another legal weapon that can be used, and you're going to see why in a moment. But the point is that, okay, at the close of evidence, the defendant, Campbell, renewed his motion for a directed verdict, asserting as a matter of law, Campbell was not a co-employee, but that in fact his conduct was that of the employer, meaning he was acting in his official capacity on behalf of the employer, and the employer is whom? That's right, the separate entity known as the corporation. Okay? He's arguing, I wasn't a co-employee. I didn't do that. I didn't do the change to the machine as a co-employee. Okay? Again, whom the only recourse was the payment of workers' compensation. In other words, if I'm not a co-employee and I'm acting on behalf of the company as an officer of the company, making a supervisory decision to change the mechanism of the machine, okay, then the only recourse for Gerger, if he gets injured by something I've done, is through workers' compensation. You can't sue me in my capacity changing the machine. You cannot sue me individually and personally because I'm acting and shielded under the corporate form. Are you picking up what I'm putting down? This is so vital and so very important and so very life-changing within this legal order. It should garner a healthy respect for this system to understand how the legal order actually operates and stop being disenfranchised by and misguided by these gurus who are trying to teach you to play outside of the system or to be foreign to it when it's an unnecessary activity. It's an unnecessary move, and it doesn't do you any good. I assure you of that, and most of you know that already. Okay, that's why you're probably here. Listen, the defendant's motion for directed verdict was held in abeyance, and the case was allowed to go to jury. In other words, the courts could have given him a directed verdict, and you're going to see what a directed verdict is and why, and the legal mechanism with having to do with its usage. You're going to see that in a moment. It's very powerful. You're going to learn several things here today, and all we're doing is going to the source, which is the law. Okay. The jury returned a verdict which found that Campbell was negligent in designing and installing the 2-button safety device. So initially, remember, we're at the Supreme Court. So it went from the circuit court to the Court of Appeals, right? And then now we're at the Supreme Court. That's up there. They're appealing the decision of the Court of Appeals. Okay, so listen. So he was found negligent in the first instance, okay, for installing the 2-button safety device. The jury, however, found that such negligence was not the cause of Gerger's injury. Okay. Following the return of the verdict, the trial court, after argument, ordered judgment, okay, on the jury's verdict and also granted the defendant's motion for a directed verdict. Okay, a little bit of wordy here, but we will get through this and I will explain. Please make sure you're hitting that thumbs up button. Proper education here today, in accordance with the law. Judgment specifically provided that the complaint be dismissed on the grounds that Arthur A. Campbell is immune from liability under the workmen's compensation laws of the state of Wisconsin. So therefore, listen, y'all, the plaintiff's action was dismissed. You see how that works? It works the same for you. The legal system works. Run to it. Don't run away from it. Learn it. These principles. We've read 2 or 3 paragraphs, and some of our minds are just blown already. Because this is all we had to do in the first place. I am making the case, and I am demonstrating before you today the corporate form, how you can use it to your effectivity, how you can avoid taxes. There's one way in here. If you didn't catch it, you weren't here. But you can hopefully put this on replay unless I take it down. I may take it down and put it over on my Patreon. Okay? Because this is power. Power 101. Listen, moving on. The Court of Appeals affirmed the trial court's dismissal on the ground that at the time Campbell made the changes in the hydraulic press, he was acting in his capacity as president of Northern and for the benefit of the corporation, and was therefore immune from suit. Let me tell you something. If I could ever get you all to stop being disenfranchised and led down the wrong path through misrepresentation of the law and the U.S. system, you will find yourself here. You will find yourself here, where the courts will order on your behalf that, wait a minute, they are acting in a particular capacity on behalf of the legal entity and therefore immune from personal liability and suit. You want to know more? That's what we're going to be doing. That's what we're going to be teaching. We are starting from ground zero over at our Patreon and through our Zoom links. I put out the challenge yesterday at the live we did. If you did not hear it, please go back and watch the live from yesterday. It's very powerful. Okay? And you'll see what we're doing moving forward. Okay? I'm waiting on 5 more individuals to join us, and we are going to bust this down. And we are going to make that distinction between the legal entity and ourselves through a legal instrumentality, which I have found, which is backed up by law. It's not conjecture. It is backed up by law. You can have your status and standing determined by court order. Then you will have what's known as a legally protectable interest. And now the courts can say and make the distinction between whether you are acting in an individual capacity or in your official capacity on behalf of the legal entity. Are you picking up what I'm putting down? Good afternoon. to you. Also, Roblox, thank you for being here, being faithful. I appreciate that. As you come in, please make sure that you hit that thumbs up button and make sure that you share this. This is hard hitting and in your face information. We are dialing back on all this misinformation and disinformation. If you are a guru out there teaching people incorrectly and profiting from it, we're coming at you. Enough is enough. This is where it stops. You understand? All right. It's up to you. Up to you. So anyways, listen, this is a very, very monumental moment in time. If you can pick up what I'm putting down in relation to this case, then you'll understand what Knowledge Well Media is offering and what we have. The truth will make you free. Moving on. It was held that even were the factors of liability present, which would have made Campbell a co-employee, such liability would only exist when the co-employee's negligent acts were contemporaneous with the injury to the plaintiff. Don't worry, stay with me. And in this case, the record demonstrated that the negligence which caused the defective design of the safety device of the machine preceded the accident by several months, meaning he didn't just make a change to the machine today and then this Gerger comes and injures himself today. This injury happened several months after. Therefore, as they stated right here, in this case, the record demonstrated that the negligence which caused the defective design of the safety device of the machine preceded the accident by several months. Okay? Because otherwise, the liability would only exist when the co-employee's negligent acts were contemporaneous with the injury to the plaintiff. Let's do you a solid and define contemporaneous. And that is so weird that the internet was already there. Let me pull it up for you. We got to define that. I don't want you walking away from here wondering what that means. Okay? So the negligence had to be contemporaneous. Let me see if I can share this for you here. One moment. I'm sure there's a faster way to do this. I haven't figured it out yet. To be honest, I have not. I've been so busy, I have not really sat down to update and upgrade this stuff. Contemporaneous, listen, existing or occurring in the same period of time. You learned a new word today. Well, we're learning all kinds of stuff today. Welcome, come on in. Make sure you're hitting that thumbs up. I got 8 people watching. I should have 8 thumbs up. Okay? Make it happen. To thine own self be true. Contemporaneous, meaning existing or occurring in the same period. Okay, so even if, let me put the other one back up here. All right, we're back. So listen, once again, now that you know we have defined the term contemporaneous, okay, such liability, okay, would only exist when the co-employee's negligence acts were contemporaneous or at the same time with the injury to the plaintiff. So the co-employee could only be held accountable for or being negligent if they did something and then at the same time the person was injured. So, and in this case, the record demonstrated that the negligence which caused the defective design of the safety device of the machine preceded the accident by several months. So it was not contemporaneous. It was not at the same time. And therefore, he couldn't even be found negligent, even as a co-employee. Moving forward. The Court of Appeals rejected Gerger's contention that Campbell, as the lessor, he leased the property, right? He bought it himself individually in his individual capacity, and then he leased it to his own company. Okay, so he's the lessor and owner was, okay, I want to make sure we got context. The Court of Appeals rejected the plaintiff, Gerger's, contention that Campbell, as the lessor and owner, was a third party entity, okay, acting in a dual capacity, separate and distinct from Northern, the employer, and rejected, for the reasons set forth above, the contention that Campbell was acting as a co-employee at the time of the injury. I hope you're following, okay? If not, we're going to do a great job of explaining. This is everything. I'm going to show you another case that'll put the nail in the coffin, okay? Just hold on. Stay with me. We're going somewhere with this. This is freedom. And guess what? It's freedom within the U.S. legal system. I didn't have to be foreign to the United States to get this, to understand this, to comprehend this, and now I can apply it. I have a legally protectable interest to apply this because I have this thing, because I'm a member of the United States, I have this thing called equal protection of the laws, meaning if it worked for Campbell, it's going to work for me. Why would I be afraid to operate as a legally competent individual within this system? I don't need the public trust to do for me. Therefore, I am not a ward of the state because I know my proper capacity and standing within the United States. I know I'm not a fictional character or an artificial person. So what do I got to run for? Why do I need to be foreign to it? No, I want to sit at the table with Mr. Trump. That's what I want. That's what I want. How about you? You want a seat at the table? Well, Knowledge Well Media is giving you a seat at the table. Let's stop acting as corporate wards. Let's stop needing the government handouts and subsidies, and let's start standing as competent, legally competent men and women within the legal order. If it works for them, it can work for you. Equal protection of the laws, due process of the laws. I'm demonstrating for you today how it works. Roblox family. Crazy. We were just discussing this topic in the car. Our child just broke her foot in a public park, just reading on how the government. I think you got cut off there. Okay. I'm very sorry to hear that. No one wants to hear that a baby is injured or hurt. If you want to discuss that, if I can be of any educational assistance, let me know. Hit me up at myknowledgewell4you@gmail.com. All right. Hope your child is doing better. But that's how the universe works. That means you are in alignment, Roblox. That means that the universe knew what I was going to be teaching on here today and put you right where you needed to be. Huh? How you like that? See, that type of stuff there reinforces what it is I am doing. I don't care about the naysayers and the dissenters. They don't want to debate anyways. I need 5 or a few diligent people, individuals ready to put it in and stop being disenfranchised by the misrepresentation, the unethical and unjust enriched at your peril. That's what I'm sick of, and that's why I'm doing what I'm doing. And this is the way we are going to teach here at Knowledge Well Media. I'm going to use the law to gain remedy within the law because the U.S. system works. You do not need to be foreign to it in order to receive or ascertain the privileges and immunities that you are owed as a competent member of the United States. If you don't like it, quite frankly, my dear, I don't give a damn. Go back to your channel and go and disenfranchise and misrepresent what is actually going on because you do not have an understanding of the legal order. Therefore, you are just like a little child who's afraid of the boogeyman under the bed. And so you wet the bed because you're afraid to go to the bathroom as a grown-ass adult. You're running from something you don't have to run from. It's a fictional system. Freddy Krueger is a fictional individual. Although today, we got some pretty loony people out there. There might actually be a Freddy Krueger now. Let's keep going. All right. This is liberty. This is freedom. Okay. On review to this court, the Supreme Court of the state of Wisconsin, Gerger is the plaintiff is asserting substantially the same arguments with additional emphasis on the argument that Campbell was in a dual capacity, still trying to double down. And hence, whatever his capacity as an employer might have been in respect to Gerger, additional and separate obligations were imposed upon him because he's trying to argue he wasn't just acting as an employer or as the president in a supervisory role. He was also acting in another capacity. That's what the plaintiff now on appeal, now that he lost his case, is trying to come back and find something else, okay? Here we go. Listen, you're about to, man, I'm hitting you over the head with some powerful elements within the U.S. system that you, after today, will be able to use. I am not giving you conjecture and documents and templates that you have to try to figure out. Because guess what? As long as I leave this video up tomorrow and the day after, you can watch this very video in parts and merely transcribe to your own understanding. And I know I'm doing a good job of breaking it down for you, making it simple. I know I am. I know I am. Haters be damned. Dissenters be damned. I know I am doing it. I'm reading it verbatim. And then I'm giving you that understanding. This is not me. This is not mine. You picking up what I'm putting down? So you will be able to use this to break it down, and you will start to apply this. Go start your corporation and employ these doctrines that you are seeing before you, because the Supreme Court has made the ruling. Therefore, you, under the equal protection of the laws, have a legally protectable interest, and therefore you can make a competent claim upon which relief may be granted. Moving forward. On review to this court. Okay, we already read that. So listen, here's another one. Here comes another one. 2A Larson, Workmen's Compensation Law, section 72.80, page 14 through 112, describes the dual capacity doctrine. Watch this, watch this. I wish I had gloves on. You know what I mean? I wish. Look, you're about to learn about the dual capacity doctrine now. We already learned about how to avoid taxes the legal way, not being foreign, not being sovereign. We already learned that when you act under a corporate capacity, okay, under a supervisory role, that you can't be sued as an employer. They can only receive remedy through workers' compensation. You are insulated by the corporate form. Now we're going to learn about the dual capacity doctrine, because the plaintiff is trying to come back on appeal to the Supreme Court and make a further argument that, well, okay, he was working as, the president. Fine. Okay, my case was dismissed, whatever. But he was probably working in a dual capacity, and therefore that other capacity he was working in voids his protection and immunities, okay, as the president. That's what they're going to argue right now. Now watch this. Watch this. Dual capacity doctrine. Here it is. Hot off the press. It ain't my words. It is a legally protectable interest under the equal protection of the laws. You can use this, baby. Under this doctrine, which doctrine? The dual capacity doctrine. An employer normally shielded from tort liability by the exclusive remedy principle, which is that that a owner or president of the company acting under the shield of the corporate form is insulated from personal liability, and therefore the injured individual can only get remedy under the workers' compensation insurance. Listen, under this doctrine, though, under the dual capacity doctrine, that employer, or in this case, Campbell, normally who is shielded from tort liability by the exclusive remedy principle, may become liable in tort to his own employee if he or she occupies, in addition to his capacity as employer, a second capacity that confers on him obligations independent of those imposed on him as the employer. Man, if you acting out, what do they say? Stay in your lane. Therefore, if you are acting as the employer under the corporate form protection, under, a supervisory role, man, stay in your lane. Don't be over here as the president of the company and then be in the cut trying to holler at an employee, trying to take her out for dinner, unethical behavior, right? Fraternization, I think they call it. Because if you get caught fraternizing, you aren't acting as the employer anymore. You are acting as a co-employee. So therefore, you waive your corporate protection. If she sue you for fraternization, you won't be able to claim that, I'm the president of the company. I was acting in a president role under a supervisory capacity. No, the court's going to say, I don't see anywhere in your policy that allows you to fraternize and abuse your power and authority in trying to get with this lady who is now suing you. Are you picking up what I'm putting down? Reminds me of Bill Clinton back in the, 90s? Huh? Was he acting as commander in chief? Or had he waived his title, his capacity, because he was fraternizing with Monica Lewinsky? Just saying. Just saying. All right, let's move forward. KBB is in the house, his house. I'm feeling good today because you know why? This is what we should have been doing all along. Not chasing after ghosts, but standing as men and women in the proper capacity, therefore taking advantage of the privileges and immunities under the corporate shield, not running from it, not trying to claim to be foreign to it, not trying to illegitimize the United States and its legal order and system. This is what we should have been doing. Any questions? It's too easy now. Whenever you come back here, this is the type of teaching you're going to get from now on. If the law don't say it, I ain't saying it. That is my boom stamp and quality assurance policy. You with me? Or go back into Egypt, into bondage, into slavery, through misrepresentation, disinformation, unjust enrichment, chasing after profits at your expense. That's up to you. But here, you're going to get that, whether you like it or not. Because even if you don't like what it says, you're still more free than being deceived and following after a misrepresentation. That's going to waste your time, your finances, and energy. You see, even if you don't like what the law says, you're still doing better than being deceived. Are you picking up what I'm putting down? Because the law is going to make you free from bondage, from debtorship, and what have you. Because you're chasing after all these ghosts and trying all these different processes, and you're going deeper in debt. Some people are losing their homes trying these things, and you know who I'm talking about. You're probably here. chasing after dreams people are selling you, when all we got to do is stay with the basis, the fundamental basis within the legal order. That's all we got to do. Let's move forward. 777. Thank you for the 777s. I really appreciate that. It's like the Batman signal. I knew something wasn't right because the wealthy operate in this capacity for generations and never experience what we have to go through. KBB, is this not simple? So simple, a fifth grader can do what I'm doing right now. Didn't take much, did it? We are uncovering the capacity which gives you corporate protection that insulates you from personal liability. Is it no wonder that the trust is such a powerful instrumentality? Legally recognized, mind you. So you have a legally protectable interest. You feeling me? So that's why the trust is as powerful as it is. It's not the only entity that will work that way. A corporation, as you see here, works the same way. So why would we need to go get a foreign trust and be foreign to the United States if they provide remedy in law, corporations, legally recognized trusts? Why do we need to run from the boogeyman? It's invisible. And as far as I know, I mean, you know, sometimes I still run up the stairs when I hear that creak behind me. But I can tell you one thing for certain. I'm still here today, and that boogeyman ain't never got me. So either it's really slow, or I'm really fast, or maybe perhaps it just ain't there. Maybe I am the boogeyman. Maybe I'm the one creating the creak in the stairs. Maybe because of my ignorance and immaturity, because I am unlearned perhaps about how wood creaks and how houses settle. Maybe that's why I have to run. There's a scripture in this. There's a passage in the scripture that says that the wicked runneth when no man is chasing them. Some of us are guilty by our own conscience, and we run because of that. Others are just ignorant of the mechanisms of the system. Maybe some of us just want the easy way out. Wherever you find yourself at today, you do not have to perpetuate it any further or any longer. You don't have to. You can change tomorrow. And Eureka, tomorrow is Monday. Guess what? You can form corporations, you can form trusts, but do it within the legal order. Stop running from the invisible boogeyman, because it's not there. As KBB says, and you're reading it right there, he has witnessed generation after generation, the wealthy elite have been doing this the whole time. That which you see here up on the screen. They've been doing it the whole time. Ain't none of them tried to claim to be foreign to the United States, and they have been insanely successful within the legal order. So stop it. I did. I hope you do too, because it's unnecessary. You're spinning your wheels. And if you teach this, you know it. You know it. So stop. Moving forward. KBB, thank you for your comment. BB Production says, don't forget to drop that like. Thank you all for showing your love. I would like to see the screen lit up with 777s. That's my number. Hit me up, y'all. Give me some 777s. Everybody, 777 right now. That's like this. Remember in church, everybody. All right, 777s. Light up the board. Light up the board. Greetings to you, James C. Lovett. Thank you for being here. Greetings to all, he says. All right, moving forward. Here we go. This is power. This is power. I feel like I got a bazooka or an AT-4 on my shoulder. Stuff got to change. Stuff got to change. I say we change it today. What do y'all say? Y'all ready to do this? I issued out a challenge in yesterday's live. Please go and watch it. I'll briefly go over it. We are going to take those who are willing. We are going to start this thing over. Okay? And we are going to start from A and work our way to Z. And not only, it's not going to be sitting here, your captive audience, and I'm just teaching. It's time to apply. I've dubbed 2023 the year of application, and by golly, and by my honor, it is the year of application. And I must produce. If I can't produce, if I can't help you, I'm certainly not going to harm you. And therefore, it will become necessary for me to stop what I am doing if I cannot produce in 2023. Do you understand me? Do you comprehend me? Are you picking up what I'm putting down? If I don't produce, I'm done this year. This will be it. I'm a man about mine. I'm not here just to fluff you and just put stuff out there in the airwaves and hope something sticks. Throw it against the wall and see what sticks. I'm not here for that. I'm not here for that. Y'all don't know my backstory. I ain't got time to waste. Okay? So if you're along for the ride, you have to get over to my Patreon and you have to join. Why? Because I am going to be doing live Zooms and whatever, and it is proprietary information. I am not putting this information out there because this one is going to produce. I put my name on it, okay? I put my channel on it. Enough with the games. Enough. I don't care who you are. I don't care how big you are. All right? I don't care. So the point of the matter is if you are along, let's go. We are going to start. I need 5 additional people to join up. Okay? I already have my Patreon subscribers over there. They are rearing and ready to go. They've been with me from day one, and I said I would not forget them. 5 more starting this week, and then we will start our courses. And not only will we be going over, everything we go over will be backed by law. Because the only way we're going to produce is if I can present to you a legally protectable interest. If it is not in law, I'm going to say this again. I'm going to keep saying it. If you cannot find it in statute, if you cannot find it in common law, then you do not have a legally protectable interest. Bring whomever, big, small, tall, dark, light, and challenge me on it. Bring them all. And I'll prove it. If you don't find it in law, you cannot have a legally protectable interest. Therefore, it is a claim upon which relief may not be granted. And therefore, the state, the district attorney, whomever you're going after, is going to move for a federal rule 12b6 dismissal. That's why you're not getting traction. That's why your stuff is not going anywhere. Because you're making a claim. Yes, you are. That's not what it says. You can make claims all day. Freedom of speech. You can make a claim all day. That's why the cop pull you on the side of the road. I don't have to blah, blah, blah. They'd be like, I know that you believe that. You see, you can make any claim you want. But Federal Rule 12b6 says failure to make a claim upon which relief may be granted. In other words, they're merely telling you, listen, y'all, listen. I can't even grant you relief even if I want to, is what the system is letting you know. Even if I wanted to, even if I think you're doing a good job representing yourself in this courtroom, the judge cannot grant you relief upon that claim. Why? It has no basis in law. What is my job as the judiciary? To analyze and interpret the law, to find the facts within the case and see if there are anything in dispute. There is anything in dispute. And then once we get it all ironed out and there is no more facts to be found, then the judge's job is to take the container of law and pour it over the top of the facts, like making a cake. The icing on the cake. You ever heard that phrase? That's what it is. See, during the legal process, from the preliminary stages, the pleadings, to the motion stage to the discovery stage to the trial, that's all stirring up the ingredients of the case. It's called the elements of the case, the cause of action. They're stirring it up, and then they're going to put that under the fire, and it's going to become a solid mass. All the ingredients, all the facts are hashed out. I got all the baking soda and baking powder broke up in there. There's no lumps in my cake batter. That's what's called the legal process, due process. And we're going to cook that thing, put it under the heat, the scrutiny of the law. And then we're going to take the icing, which is the law itself, and pour it over. We're going to see what the legislature intended behind the law. And we're going to pour it over the cake. And that baby's going to be great. That baby's going to be great. It's going to taste phenomenal if you did it right. That's called due process of law. That's why you must find your remedy in the law. You cannot find it outside. You cannot make up your own things and think that they're going to recognize it, because that would be in breach of their trust duties. It would be in breach of the legal order. It would be in violation of due process. And if they do that, they waive their their qualified immunity. The judge cannot just arbitrarily and capriciously get up there and, because he likes you today, grant you a win. Because you have fervor and passion behind your dissertation, your lecture, you know what I'm saying? It might look good, but when he opens the Lamb's Book of Life, that argument, it's not backed up in law. I cannot grant you any relief. They're not just coming off the dome. This is 200 plus years of common law, case law. What makes you think you could just get up today and generate a contract or generate an affidavit and think that they got to act on it? Are you foolish? If there is no law to back it up, you have no standing in law, meaning relationship. All right. Let me breathe a little bit here. Calm down. We all need a little water break. It's been about 1 hour and 30 minutes. I need you all, please, to listen. Just hear me. Listen and hear me. Okay? Hearing me, we hear all kinds of sounds. I hear birds and stuff outside. That don't cause me to do anything. But when you listen to someone, then it causes you to do something. You got to put activity behind that which has been delivered to you, that which has stimulated you. That you have to know this is truth, y'all. You just have to know it. Any claim you make must be backed up by law. We have to stop this for these frivolous suits, frivolous filings. This is what they're telling you. This is why they're telling you that I cannot accept your filing unless you could show me a statute. I've had that literally said to me. I know some of you have too. They'll literally tell you, unless you can show me a statute, I'm not filing this. What do you think they're saying? They're saying they have a job to do. And just like this case here between Campbell and Gerger, if he is found to be acting in any other capacity other than his official capacity as the president, acting in a supervisory capacity, if he is found to be acting in a dual capacity as what we are on right now, then the other side can argue that, wait a minute, nope, they waive their immunity. Do you understand? In other words, if the county recorder is found to be acting in a dual capacity and not in the proper capacity when they accept your filing, they can be personally held liable. That's why they don't accept your filing. A little bit more, and then we'll get out of here. Okay, get over to the Patreon and join us. I'm not going to keep warning you. Get on over there because we are going to take off as soon as I get the first 5. we're taking off. I'll give you the link to the Patreon. And we're going to do this right. And we're going to we're going to apply, and we're going to ascertain and obtain our remedy. We will have a declaration of your proper status, not by an affidavit. No, in the law, because I have found in the law your and my legally protectable interest to have our status defined. We found that. Don't you forget where you heard it, and don't you forget where it was found first. Anybody else that comes after me? So anyways, a little bit more, and then I'm going to get off of here. Let you enjoy your football game. Listen, under the dual capacity doctrine, under this doctrine, an employer normally shielded from tort liability by the exclusive remedy principle may become liable in tort to his employee if he occupies, in addition to his capacity as employer, a second capacity that confers on him obligations independent of those imposed on him as the employer. For reasons to be discussed later in this opinion, we conclude that the dual capacity doctrine is not applicable under the present fact situation. And we also conclude that under the circumstances here, even conceding that Campbell was negligent, such negligence occurred in the course of the non-delegable duties of an employer to furnish reasonably safe tools and equipment to an employee. Non-delegable meaning it is his or her responsibility as the president or as the supervisor over the employees to provide safe tools and equipment. That's a non-delegate. I can't pass that on to somebody else and make it somebody else's responsibility. Therefore, I am shielded because I have no choice. I am putting these people to work. Therefore, I have to protect them as the supervisor. I can't delegate that to somebody else because the law is going to come to me and say, did you provide safe equipment to your employees? OSHA is going to come looking and knocking on my door as the supervisor or employer and say, why didn't you have, he's up 6 feet high, he's supposed to have a harness on. If he falls from there, you as the supervisor or employer or whatever is going to be held liable. That's a non-delegable duty. Are you picking up what I'm putting down? You can't pass the buck. The Wisconsin law in regard to the liability of co-employees was well summarized in Laffin v. Chemical Supply. Okay, to recapitulate the teachings of Laffin, that case and the decisions cited therein pointed out that, I think I'm going to fast forward past this. Well, while it is true that an injured employee may maintain an action against an officer or supervisory employee, he cannot do so if the conduct of the officer is in his capacity as a corporate officer or supervisor while acting on behalf of the employer. I'm just going to state it plain and simple. Put yourself in this situation. Equal protections of the law. What capacity are you acting in on behalf of the legal entity, which I can prove hands down is separate from you? In law. My question again is, what capacity are you acting in? Because, reading again, while it is true that an injured employee, let's draw this out. Let's draw this out and then we got to get out of here. I'm going to do you the biggest, most powerful favor today. I hope you appreciate it. I hope that you will light me up with 777s. I'm going to set, or this information is going to make you free today. Listen to hear me out and listen to what I'm about to tell you. I'm about to break it down like good science. Hold on. I got to address something here. Ray Cosmic, what is your insinuation behind that statement? You said only Patreons benefit? So are you suspicious of my activity? Is that what's going on here? You don't have to be. I'm pretty straightforward. What is your question? The question is only Patreons benefit? Yeah, only patrons benefit from the exclusive information, the teaching. Yeah, I don't have to. I'm already teaching for free right now. What do you want me to do? Can I support my family? Huh? This is 2 hours on my Sunday. I'm supposed to be cutting grass. I'm supposed to be cleaning my garage. I'm supposed to be getting my children ready for school tomorrow. You mean I got to just do this? You want me just to do this all day long? You know, every other day? You want me just to come on here for 2 hours and just burn time and energy? Is that what you're expecting? If I'm wrong, just tell me. If I'm wrong, please let me know I'm wrong. You mean I can't have built you? So Ray Cosmic, are you telling me I can't have built a separate platform that I'm inviting you to, that I'm not gouging you? It's $15 a month. Somebody do the math on that. Let's see. Let's see if I'm being unreasonable here. Let's see. $15 a month. What does that work out to? I think maybe I'm being unreasonable. Let's just see. So, no, I did that wrong. Somebody help me out. I'm kind of agitated by this right now. And no, don't get me wrong. I'm not against your free expression. I'm just addressing what you're saying. So don't, please share your opinion. I have no problem with that. I never shut people off on their opinion, but I'm going to address it. Since you're putting it here, I put it up on the public thing so everybody can see. So your question is only, why can't I figure this out? Somebody, thank you. Wait, KBB, is that correct? $15 a month. Well, there's 30 days in a month. I don't know why it's not computing here. For some reason, I'm just shut off on it. $15 a month. Somebody help me out. How much does that translate per day or week or whatever you want to do? 4 weeks in a month. $15 per month. Divide 15 by 4. I'll do it. $3.75 per week. You give more than that to McDonald's to kill your ass. And I'm setting you free. This information is free. And I'm giving it to you free here today. So you mean to tell me I can't create a separate platform that I can actually use to garner finances to support my family? I can't do that? $3.75 per week for this information. Have we put this in proper perspective? again, I went live yesterday for at least 2 hours. I'm live again today for another 2 hours. Check all through the archives. How much do you want? See, this is what I'm talking about. This is what I'm talking about. I'm gonna stop. I don't want to get all emotional about that stuff. I think you understand. I hope you understand what you're picking up what I'm putting down. And again, I respect your opinion. Let me get back on. So yes, to your question. I don't want to avoid your question. Yes, you have to be a Patreon subscriber in order to take advantage of the new offering where I would dedicate study and time. You see all this? This is real. This is not a prop. This is all real. I literally do. I literally do. These things move. This is not a backdrop. I study this. I put the time in. And I've been doing it for 8 years with little to no support. So yes, you in order to take advantage of this new offering, where I am going to meticulously walk you through building your trust, a simple trust, not a foreign trust, because I need you to be able to operate within the United States. How can I come through on my offering if you go to a bank to try to open a bank and they tell you, oh, it's a foreign EIN? We don't recognize that here. Sorry. Then you could take the occasion to say, you said we were going to do this and be able to do this, and we can't because it's foreign and they won't take it. I got to go from bank to credit union to this to that. Do you see? You ain't going to get me like that. So in order for me to come through, I have to bury everything, all my assertions and claims in the law so that you can have a legally protectable interest so that you can actually exercise these things, unlike you've been doing for the last 5 years. As all these gurus have been disenfranchising you and misrepresenting the law or your rights to it. That's not going to happen here. The buck, as they say, stops here. So yes, in order to take advantage of that, yes, you will need to be a Patreon subscriber at $3.75 per week. And hopefully that doesn't make me suspicious. Chris P understands it, apparently. You should join and support. KBB understands it. Time is energy, and energy is wealth. Roblox, I myself had been pulled out of my car by police let me close this down. So anyways, I'm going to be right back to your comment. I'm not shutting your comment off. Here, this is free. This is free. You see at the top of here, you can go and finish this yourself for free. I won't charge you a thing. I don't like being an asshole. That's not what I want to do or be perceived as, because I'm not that. If you met me, I would give you anything. If you were pulled over on the side of the road, I don't drive past people stalled on the side of the road. I literally stop. And when they try to offer me money, I usually refute it unless my family desperately needs it. Then if they offer me a $5 or $10, thank you very much. My family will greatly appreciate this. That's how I function. I don't take advantage of people. Okay? Go back in my archives. I got over 300 videos that'll demonstrate just what I said. Free. Free. Okay? I'm not a suspect. Don't put me on a suspect list. Yeah, unless you know my track record, unless you know where I came from, who I am. If you don't know who I am, why are you gonna make that claim, man? I mean, I don't understand that. But whatever, it's your right. I'm gonna take this down and get back to we're gonna close out here. It's been an hour and 46 minutes of my time. I myself had been pulled out of my car by police as a passenger 2 minutes into a stop, had to miss work, etc. Was discouraged to claim injury because officers have immunity. That's on the table, Roblox. Worry not, fret not. They're already discussing that, actually. I don't know if you're privy to these actions that are being considered by the courts, and people are complaining as to whether police should enjoy what is known as qualified immunity. So fret not. But you know what, Roblox? We're moving forward. We have the remedy here at Knowledge Well Media. Fret not. Okay? We're going to take care of that. Chris P says, I came in late. I have to go back and watch from the beginning. Please do so quick, fast, and in a hurry. I'm not sure if I'll leave this up. I'm just not sure. I gave mega bombs here. Okay? This really should be for my Patreon subscribers who support for $3.75 per week because they value the information. Let me tell you something. Value is defined as the amount someone is willing to pay for something. You're not going to pay for something that you do not value. So whatever you want for free means you don't really value that. Enough said. I would hope that you value me in this information. If you don't value me, I hope you value this information. I put a lot of hard work in. 777, thank you, Roblox, as usual. Yep, we figured that one out. Roblox family, this information is available free. This is just a platform to share and learn with like-minded individuals. Invest time and money into yourself. Brilliant. Absolutely brilliant. Somebody gets it. Chris P says facts. KBB says double facts. I like that. KBB, with sacrifice to learn off mistakes. All right, 100. Roy Cosmic, why is my response to your question blacked out? I didn't black it out. Wait, where is your response? Wait a minute. Man, you under a lot of suspicion of me. Wait a minute. Let me look. I didn't see any. This is your first response or your first assertion. Unless one of the mediators blocked it out. I didn't block it out. I'm looking for it right now. I don't see another response. You said only patrons benefit. And then I'm looking through here. And the next, yeah, I didn't block it out. If somebody else did, I will check. Mediators, let me know if you blocked. Did you block Ray Cosmic's response? See, I don't play those games. Again, don't jump to conclusions. Just ask a question. Well, you did ask a question, but I didn't block it out. I don't run from anybody. Shit, I'm 46 years old, man. I'm done running. I ain't running from nobody. I ain't scared of nobody. Whatever, I take it however you want to. I didn't block anything out. Mediators, did you block anything out? Chris P says, I have to start joining these lives. I always miss them on Sunday at 11, somewhere between 10 a.m. and 11 a.m. Central Standard Time. Hopefully you start catching them. They're just as good on repeat though. Okay, you can look back in the archives, go to my YouTube channel, and they're there unless I take them down. BB Product, Kimberly, thank you for being here. Welcome. Joseph Henson says 777. Chris P says, I'm subscribed to the Patreon. I'll catch it on there if you take it down. Absolutely. Oh, thank you for confirming that you are there. And Ray, share my response to your question and stop defending yourself. Okay. Ray Cosmic, put your comment up and I will wait for it. It's not here. And I'm not, what do you? I'm waiting on you, Ray. Put your comment back up. We will hold the show on just for you. Meanwhile, let me put the Patreon up. So those of you that are serious about your education and are ready to go, let's get on over there and subscribe. I'm waiting on the next 5. 5 subscribers, and then we will begin from square or ground A or A to Z. We're going to go. And not only will it establish your simple trust, we'll also generate the declaration for the courts to consider your proper and true status distinct from the legal entity, so that you can employ the case through and by a legally protectable interest, as we found here in this particular case law. One thing that you should understand and understand is that a case in the state of Wisconsin may be used as what is known as persuasive authority in your state. What I mean by that is, sometimes the courts will be like, well, I'm not obliged or I'm not obligated to necessarily recognize another state's holding, okay? But what you do is you put in your drafting that you want the courts to take judicial notice of this case from the state of Wisconsin, and to construe it as persuasive authority, okay? And secondly, because it is the state of Wisconsin Supreme Court, okay? So that's the high court. So you ask them to construe it as persuasive authority to have weight in their decision making. Are you picking up what I'm putting down? That's the proper way. See, there's always these legal procedures, the proper way to deal with the legal order. Okay, you can't just come in there and drop it on their lap and say, because I'm a natural man, I got these rights and you're illegitimate and blah, blah, blah. You can't illegitimize the legal order. You can't do it. It's an act of war. You can't do it. Patreon.com. All right, we're about to get on off of here. I appreciate you all. I'm Ray Cosmic. I think I've been more than equitable in waiting for your response. I don't see it here. None of the mediators have said that they've erased anything. So at this point, I got to call BS on your assertion. I will wait 1 more minute for you to drop in this. Oh, okay. Here we go. I was a frontline activist and community organizer for 50 years. They took out my family and friends trying to silence me, which only tripled my motivation. It was an unpaid position. How much is... I don't even know. Okay. You were a frontline activist for a community organizer for 50 years. Did you go into that with the understanding that you're not being paid? Now, if you were a community organizer for 50 plus years, you should be old enough to understand when you're working for a nonprofit, you don't expect to be paid. Or if you're an activist, they took out my family. I don't know who they are. And friends trying to silence me, which only tripled my motivation. Then that's your motivation. It was an unpaid position. So what are you expecting? If you knew it was an unpaid position, then how are you trying to hold a candle to what's going on here? You are here freely today. I did not charge you 1 dime. So what is the problem? Didn't you get 2 hours worth of content for free? This is my community activism. You're welcome. Are we good? All right. Again, I'm not trying to be an asshole, but you're kind of coming for me, and your accusation is baseless. Unless I'm wrong. If anybody else feels the same way as Ray Cosmic, then let it be known. I'm a man. I can take it. If I'm wrong, then let me know I'm wrong. Ray KBB says I knew it. All right. Ray Cosmic, yes. All right. With that being said, I think everybody would like to be released from class today. The bell rang like a half hour ago, and therefore we're going to release everybody. Enjoy your Sunday, the rest of your day of sun and inspiration. And we learned several things, right? The term contemporaneous. We learned a legal capacity. All right, Ray Cosmic. I could not bear the thought of their deaths being in vain. I busted for a living. All right. All right. I'm sorry for your loss. I don't know who they are. But okay. All right. Crispy says he's trolling. All right. I don't know. Maybe he's an older gentleman, you know, that has some kind of trauma. I don't want to be insensitive about that. But you got me pegged wrong, my guy. Okay? You got me pegged wrong. So anyways, I love you all. Thank you for being here, for supporting. We will see you back here again, if not sooner. Again, I'm starting to do those midweek uploads and research projects and all that kind of stuff. So please join me. Look out for that. If you have not already, please subscribe and hit the notification button so that you are notified at each upload. Okay, we are moving. We're going to move much faster. We got to close out 2023 with applying and getting us some remedy. And then 2024 is going to be the distinction from knowledge between Knowledge Well Media and all these other so-called gurus out here. I'm not going to be lumped in. Knowledge Well Media will not be lumped in. And when we ascertain and obtain our remedy and we get those declarations and court orders and we're moving through the system the way that we are supposed to move through the system, I'm not hearing anything that they have to say, they being the other gurus or whatever. You could, if you want to get in, you get in the proper way, just like everybody else. Okay? That's the way it's going to be. We do equity over here. All right. I hear you, sis. I hear you. All right. With that being said, I love you all. Don't forget that none of this is to be construed as legal advice. We'll see you back here next week, Sunday, excuse me, for our live inspiration, Day of the Sun, and somewhere is 10 a.m., 11 a.m. Central Standard Time, so you don't miss it. All right. I love you all. Thank you for being here. And let's go forth and let us conquer. But within the law, that's the move. Okay. I love you all. Thank you. Now you've been made free. The question is, what are you going to do with it? We'll see you soon. Thank you all. And thank you for your comments. Keep them coming. See you all. Peace.
Start your journey today by liking, subscribing, and sharing our YouTube channel, Knowledge Well Media, or by going to our Square site at knowledgewell-media.square.site and perusing over the available content and information. Also by submitting your email at the bottom of the Square site page in the Stay in the Loop section to receive priority information, specials, and other insider details. Or by signing up for a 1-hour consultation to tailor your specific educational needs in beginning your journey. You may do so at the aforementioned Square site, once again at knowledgewell-media.square.site.